Well, good morning. We are delighted to join you this morning to continue what we have been coining our top 10 Title IX series webinars. Last month, for those of you that were with us, we kicked off the new year with a webinar covering the top 10 questions that school administrators have been asking about Title IX. So today, we're going to continue with our top 10 series, and we're going to be taking a deeper dive into one topic that we did touch on last month's webinar, which are investigations. So I'm Amy Dickerson, a partner here at Franczek, and I'm delighted to be joined today by a number of our attorneys on our Title IX team here at Franczek: Jennifer Smith, Caitlin Atlas, John Swinney, and Ellen Luking. So our Title IX focused webinar today will be addressing the top 10 reminders that school administrators should consider when approaching and conducting investigations under your Title IX grievance process. So we've collectively put together a list of the top topics that we often get questions about, or just find that reminders on these topics to be valuable and important when it comes to conducting Title IX investigations. So similar to last month, we'll be reviewing these from a high level, as our webinar today will just be 30 minutes long. And, to give you a little bit of a glimpse into what we'll be going through with our top 10 list. We'll be pretty much going through with a couple, different insights here and there, sort of the anatomy and kind of chronology of the investigation process, to both give a little bit of a refresher and some tips and kind of key things to keep in mind. Our goal, though, is to address sort of those key things to keep in mind about each topic. Again, from a high level. So as always, we're available to dive deeper and answer questions specific to your institutions when you reach out to us directly. And as many of you know who are joining us today, we regularly offer trainings on these topics, including investigations, where we're able to really dive deeper and provide some deeper training on the various aspects of investigations. As a reminder, if you do not already subscribe to receive our Title IX blog alerts, please do go to title9insights.com to sign up so that you can get our alerts and updates on any alerts we give out, as well as training updates. You can also find out more information about our trainings or toolkits that we offer by emailing us at title9@franczek.com. Again, while we will be going at a fast pace today, if you do have any questions, we encourage you to use the Q&A function, and we will do our best to answer those questions as we are together today, or can follow up after. So with that, we'll go ahead and get started, and I'm going to kick it off with our first topic, which is investigator training. So we wanted just to start with this topic, as this really just should be the starting point for all schools when determining who may be available at your institution to serve on your Title IX team as an investigator. So while John will next be discussing things to keep in mind when actually selecting a particular investigator for a particular case, you'll want to ensure, just sort of from the get-go, that you have a sufficient number of individuals trained to serve as investigators, which hopefully you all that are joining us today do. And of course, as you might have staff turnover, this is something that you should re-examine each year. So the training that anybody serving as an investigator must have is that required training that any person serving as an investigator, decision maker, informal resolution facilitator, or Title IX coordinator has to have under the Title IX regulations. So you want to make sure that the training is based off of the current regulations, which are the regs that are effective in 2020. So for those of you that have had new staff come on and you're inquiring as to whether or not they've previously gotten Title IX training, or whether you need to make sure they do get trained, you'll want to make sure that you clarify when did they get that training to make sure it's under the current regulations. We do also recommend considering providing your investigators with training on best practices for conducting investigations generally, at some point beyond just the required training under the Title IX regs. This could be training that's specific to the Title IX process, or just generally. But having investigators who have been able to get some training on honing key skills like conducting interviews, note-taking, documentation, and trauma-informed approaches can go a long way with making sure that you are really conducting valuable and sufficient investigations. So, in addition to those trainings, providing your investigators with support along the way, once they are selected to serve as an investigator for a particular case, can really be valuable and something to keep in mind. Giving reminders about key procedural steps from the very beginning, making sure that they have your current policies and procedures, providing direction on your expectations for how they coordinate with the Title IX coordinator when giving outreach to or having outreach to the different parties or witnesses. Things like that can also be really critical to ensure that they feel well supported throughout the way. As a reminder, we do have several training options, including, in-person and virtual, and are always happy to discuss ways to support you in that area if that is a need for your institution. And our Title IX toolkit, for those of you that have it, also includes various checklists and flowcharts that can really help serve as key reminders for investigators as they move through the investigation process. That may be something you want to consider providing to them when they get assigned. So with that backdrop in mind, I will turn it over to John now to discuss things to keep in mind when selecting an investigator for a particular case.
All right, thank you, Amy. So with that in mind, the training requirements in mind, let's talk about one of the most foundational steps within the Title IX process, which is selecting your investigator, right? The investigator is kind of a vitally key role within your Title IX grievance process because I know that this goes without saying, but they are the individual that is responsible for investigating, which means that they are the individual that is identifying parties and witnesses, interviewing those individuals, gathering and assessing evidence, sharing evidence, right? So it is a vitally key role, and it's very important that you're aware of, what their requirements are, the qualifications, and what the regulations say about the investigator to ensure that this very important part of your process is being done with fidelity. So the 2020 regulations do have tighter requirements around the selection of an investigator than what the 2024 regulations had, pertaining to investigator qualifications, impartiality, and conflicts of interest, and even kind of the separation of roles within the Title IX process. Beginning with that first piece, that role separation, under the 2020 regs, there does have to be almost kind of a siloing between the different Title IX positions that are involved in the grievance process. So that means, and that includes your investigator. That means that your investigator cannot also be the decision maker. They can't be an appellate decision maker, right? They have to just solely be the investigator. Under the 24 regs, we saw a little bit of kind of a blurring of that, right? Where your investigator maybe could be the decision maker as well. That is no longer the standard that we are using here. The Department of Ed, their position is that by kind of keeping these siloed, you're ensuring the fidelity of the investigation and the decision making are both free of bias, free of conflict of interest, and will, reach a more fair outcome. That's their justification for that. But just as a reminder, we are back in this framework where each of your individuals that are involved within this process along the way do have to be siloed. In terms of qualifications for a Title IX investigator, the 2020 regulations that require that any individual serving as an investigator, as I've mentioned, be free from a conflict of interest, be free from bias against either the complainant or the respondent, and must be properly trained. I know that Amy talked, briefly about training, but we're talking about training on things like the definition of sexual harassment, the scope of the institution's education program or activity, so that they can actually understand, the context of the conduct in order to determine whether or not it is relevant, right? Because relevance is another thing that they need to be trained on. They need to understand what evidence they're collecting, what questions they're asking, and how those are relevant to the investigation itself. They need to be trained on how to serve impartially and how to serve in a manner that is free of bias and conflict of interest, including perceived conflict of interest or bias, right? We often, I think, kind of think of a factual conflict. Well, there wasn't actually a conflict of interest here. There wasn't actually bias here, but that perception is just as important too, which is why that training is so vitally important so that they know how to conduct themselves in a way that they're not potentially creating issues for you down the road by having created a perception of some sort of impropriety with the investigation. And like I said, issues of relevance, that's a huge one for investigators to be trained on as well, because their whole job is determining who do they meet with, what do they ask, what evidence are they gathering. They really have to understand what is or is not relevant to the investigation at hand. As Amy mentioned, we do offer trainings on all of these things. So, feel free to reach out if you ever have any questions or if you're ever interested in looking at one of those trainings. But, from a high level view, qualification of the investigator, siloed and trained. Um, I mentioned this briefly. I just want to touch on it again. Conflicts of interest and bias. It is one of the requirements that the investigator be free of the conflict of interest, be free of any bias for or against either of the parties. And in making a determination as to whether or not a certain investigator might be proper for a certain investigation, some of the considerations that you might want to think about are institutional bias. Is there any reason to believe that this investigator might have a bias, for or against the institution itself or against one of these respondents or the complainants? Friendship or relation with either party, again, actual or perceived. Is there any reason that one of the parties might believe that there is some sort of friendship or outside relationship between this investigator and either the complainant or the respondent? Or even potentially personality conflicts, right? Are we noticing that there is maybe just an interpersonal conflict between the investigator and one of the parties such that there could be a perceived bias against them? Right? That's something that you want to take into effect, again, to ensure that the investigation is and appears to be fair, right? You want both of those things.
John,
I may
on
plug,
that
go
we
ahead.
it might seem kind of superficial, but we've seen case law where there's plaintiffs out there suing to say just the investigator was mean to me.
Right.
Like that is a common legal claim. So I just want to put an emphasis. This is to actually avoid legal claims. We have to be equally nice. Or at least if we're going to be mean to one party, we have to be equally mean to the other party in those demeanors, smiles, that kind of thing. Yeah.
Yeah, you might be sitting there like, why is an attorney telling me to be nice? This seems like weird legal advice. Well, because it can create legal issues down the road, right? So again, avoiding that perception of any kind of bias is vitally important. I do want to plug one quick reminder before turning it over to Ellen to talk about written notifications. But the reminder that the investigator, in addition to the duties that I mentioned earlier of identifying witnesses, speaking with them, collecting evidence, the investigator also, at the end of the investigation, also does have the obligation of sharing the written report and sharing out the evidence, the relevant evidence that's been collected. I think we sometimes get questions about that, or, you know, sometimes educational institutions might skip a step, and this tends to be one of them, right? But you do have to share that directly related evidence with the parties in order to give them an opportunity to review and inspect that and then ask questions. So the investigator, that role also encompasses this. I'll talk about that a little bit later, but I kind of wanted to plug it here just because I think that it's something that sometimes gets skipped. With that, I will turn it over to Ellen.
Thanks, Sean. So I get to talk to you about written notification, and I think this is one where K-12 institutions get it wrong because it's so uncommon whenever we're talking about student discipline things to give a written notification to students before we start interviewing them. So I think that whenever we talk about this written notification before interview, it's helpful to have the backdrop of how we got these Title IX regulations. Due process for respondents was a huge concern and was a massive part of the reason that we got these 2020 regulations that we now have to operate under. There was concern that respondents were essentially getting railroaded in these kinds of proceedings. They weren't being given notice. They weren't being given that meaningful opportunity to respond, a very basic principle of due process. So with that in mind, my reminder here to you is to please not forget that parties are entitled to a notice of allegations, which is going to include what the actual allegations are, something that I review notices of allegations fairly frequently, and some of you I can see in the audience have been subject to my directive of saying that there was inappropriate conduct isn't descriptive enough. Like I want you to actually use the words that were said or identify what body parts were touched. I don't want to see those inappropriate and violated the code of conduct. I want to hear hand was used to touch what. And it's so common in K-12 institutions that something happens and a building administrator calls a person down to the office and says, what happened here? I think what's really important here is that all of our building level administrators know, hey, pause. If this is dealing with sex, pause. We need to get the Title IX coordinator involved so that we give that written notification before we start our investigations. We have to have a written notice of allegations to initiate an investigation, and then we have to have written notice of the interview before we start questioning people. So that's my reminder here. Parties are entitled to a notice of allegations and a written notification before the investigation starts, because they're entitled to that opportunity to build their defense before they start getting questioned. At this time, I'm going to turn this over to Caitlin, who's going to talk to you about what we expect to see in those interviews.
Ellen, before you turn it over, I do just want to bring up a very quick reminder here too,
Yeah.
or to stress what she said. I was working with a school district lately where they essentially told me that they start initial investigations before determining whether or not it's Title IX conduct in order to like confirm in their own mind whether or not it actually should follow the Title IX process. And I understand that, right? I understand that desire to not want to kind of prematurely initiate a Title IX process. However, as Ellen is saying, as soon as you have that reason to believe that this might be something that falls under Title IX, stop and talk to your Title IX coordinator and figure out whether or not you need to follow the Title IX process in order to then provide the correct notices, follow the grievance procedure, which could be separate from any other kind of like UGP or Student Code of Conduct investigation. So just wanted to stress that, we understand where that mentality comes from, but it is vitally important that you pause and talk to your Title IX coordinator.
And Jen, on that note, well, we don't have time to really talk at length today, but we do discuss this in our trainings. There is a difference between intake versus investigations, which may be where that line can be drawn. So, there's room for and can be very helpful to do intake, but that's different than investigation. So again, that's something that, as those of you doing our trainings know, we talk through that.
Right. And when Amy's talking about intake, we're talking about talking to the complainant. Like, we can talk to the complainants to get an understanding of their claim here. What I'm asking you not to do is drag the respondent down to the office and begin your investigation.
The other, specifically with pre-Title IX investigations, we can investigate if we don't know who the respondent is. So if the purpose of investigating is, someone says a student with this description, in order to launch it, the Title IX process is all about, like Ellen said, providing notice and opportunity to the respondent. If we don't know who that person is, we can investigate enough to figure out who it is, but once we know, then that person is due all these things. That's the only like major exception I know where you might launch into a bit of a real true investigation just to find out the missing identity of the respondent.
Okay, well, I'm going to jump in while I have the chance. I will follow up on one thing Ellen said is the specificity in that initial notice. I had an investigation a year or so ago. It was a staff-on-staff investigation. We got involved at the very end, and the initial notice letter basically said, you are accused of sexual harassment. We need to actually tell the person what they are accused of doing. Sexual harassment, as all of you know from sitting in our Title IX trainings, is a very, very large umbrella and can mean everything from sexual assault to commentary to touching. I mean, it just covers a lot of activity. We need to be specific. But I am assigned to talk to you about note taking. So when you are meeting with individuals as part of the Title IX process, you need to be taking notes in those interviews. And you want those notes to be detailed because when you go to the exchange of evidence process, those notes are part of the directly related evidence, and you're going to need to give them to both parties. So a couple of pieces of advice. One is be factual in your notes. It shouldn't be impressions or opinions, just really what the person said. And if there's a specific quote that you find very important, put it in quotation marks. Make sure those notes are very specific. The person admitted to X. They said Y. Now, I know I struggle a lot when I'm in interviews, both under the Title IX process and other processes. I'm just trying to get down as much as possible. But if someone else were reading them, they would not be able to follow. So my recommendation is as soon as you get out of that interview, as soon as reasonably practicable, you go back through your notes and make sure everything makes sense. There aren't typos that, something says did happen and should say did not happen. Make sure you're cleaning up your notes. And make sure you're taking them with the frame of reference that both parties are going to be reading these later in the process. So we really need to make sure they're accurate and somebody else can understand them. If no one has anything to add on note taking, I will turn it back to Amy to talk about the review and follow-up in the process.
Thanks, Caitlin. So one issue that I always like to touch on in trainings is the importance of conducting a careful review and any necessary follow-up of all of the interview notes that you have accumulated during your investigation and the evidence that you've gathered before your investigators conclude their investigation. So, I'm thinking of that time where the investigators believe that they've reached the end of their investigation and are ready to engage in the sharing of the directly related evidence process that we'll talk about next. But before getting to that stage, I really do encourage all investigators to review all of their interview notes carefully, along with the gathered evidence, and consider whether there are any open questions, lingering issues, or disputed evidence that might require additional follow-up with any party or witness. There may be issues, and likely usually are, that you did not know might be present when first interviewing someone, but are now apparent after having talked to others and having received conflicting or new information. And, this really comes from a place of, reviewing an investigation file and, in doing that process, seeing like, oh, well, what was the complainant's response to something that the respondent said in their interview, or to, the fact that something was stated in a text message that isn't quite consistent with what one of the other parties said. Having an eye towards those questions and conducting where necessary any follow-up interviews can go a long way at really helping your decision maker ultimately get to the questions that they need to answer and help grapple with any potentially disputed evidence. So before determining your investigation is done, consider whether any of that follow-up is needed, and then take those steps to complete that follow-up at that time if needed.
We did get a question in the Q&A that I can give just a quick guidance to. The question is, how do you recommend speaking with young children regarding specific body parts? Most do not know correct terminology. So this, if you're doing an investigation involving young children or individuals with disabilities that have a hard time, that have communication language issues, I recommend relying on your experts in the district to provide and or the parents. So both of those resources. So whether it's the teacher or a speech language pathologist in the district or social worker in the district, even though you're the investigator, you don't necessarily have the training and expertise to effectively communicate either with a young child or with a individual with disability. Rely on your internal district experts. You can have support of another person for the interview, even though you're the investigator. So rely on those resources. I also think parents, obviously Ellen talked about we're giving written notice. This is not something where you want to be talking alone to a small child about private body parts. Like, you want the parents there. I would tell them in advance that you have questions about a private body part and ask how they talk about it as a family. If they want to even ask the question just with you in the room, there's no reason we have to be too rigid about our approach. And of course that assumes like a child advocacy center is not involved in doing the interview in the first place. If you actually have to do that type of interview, which I'm a little bit leery here. If we're talking to young children about touching private body parts, it may be that you're not even doing that. It should be referred out to a CAC. Maybe, depending on the situation. So anyways, I just wanted to quickly touch on that.
Thanks, Jen. And then I'll turn it over to Ellen now to talk about evidence sharing.
Perfect. Thanks, Amy. I just have one thing to add to what you shared. Something that I've been doing recently is asking administrators when they're wrapping up their investigations is to go back and look at their investigation and and match it with the definitions of the sexual harassment that someone has been charged with, and make sure you have attempted to collect evidence on each of those parts. Because what I found fairly recently is that we're forgetting to ask the question of how has that impacted you, which creates some difficulty in finding hostile environment sexual harassment, and also creates some difficulty in figuring out what remedies are best for the complainant. So after that, we have to share the evidence. John talked about it some, and it's a part that is really forgotten, like John mentioned. It's something that I've seen forgotten in 2 investigations in the last 2 months. So it's a common forget, and I think that maybe that comes on the back end of the 2024 regulations, where we had been trained of a sort of a one-phase process where we could either share an investigation report that fairly summarized everything, or we could share the evidence itself and immediately move into the decision-making phase. But we're back in our 2-step Title IX rules of 2020 process, where we have to share all of the directly related evidence before we can move into the investigation report process. And like Caitlin mentioned, that's going to look like your notes from your interviews with people. It might also be copies of emails, of text messages, of pictures, summaries of videos, written statements. Any of those sorts of things are going to be shared in some sort of folder or file with all of the parties to the complaint. So remember, we don't always have just 2 parties. Sometimes we can have more than that, but we're sharing only with the parties to the complaint. We're not sharing with witnesses. And when we're sharing that evidence with the parties, it's important to include information regarding what the parties are entitled to do in response to the receipt of that evidence. And we have sample notices for that in our toolkit, informing them that they have the right to respond, that they have the right to, suggest witnesses, that this is not the completion of the investigation if there is some additional information that they would like to add. So with that, I'm going to turn it over to Jennifer to talk to us about what comes after we've shared our evidence.
Yeah, so after we share evidence, we have to write a report, and the most important, in my opinion, part of the report is where you're making decisions about or recommendations, at least about what the findings are. What did you find in your investigation? Who did you find credible? One trend I'm seeing that I've seen online and seen in cases we've handled or where there's appeals or litigation is where I think people put it maybe into an AI situation, and they get, it's recommended that they use some sort of rubric for determining credibility. I've seen like point systems assigned. You get, so many points for different indicators of reliability. And I've seen, I have major concerns about reports that impose some different standard for determining credibility that's not in our policies or procedures, that we just find online as a helpful tool, but then we impose it as this is how we decide credibility, or this is how we decide responsibility. I think we need to stick just to the legal standards. We're looking at the totality of the circumstances and whether it's more likely or not that the thing happened. For credibility, we're looking holistically about whether something's more likely or not, does it have some artificial indicators? And a lot of those rubrics, I mean, I like the concepts they put out there. They look at things like consistency, corroboration, level of detail, plausibility, motive to falsify, demeanor. So all of those are things that you could use to, as a like a writing prompt to get you going or think about things that might determine credibility. But if you use them in the way that AI might spit out at you, I think we're setting ourselves up for trouble legally. So with that, John, do we share
Yes.
the report?
Yes, and I'm cognizant of time, so I will run through this quickly. But yes, in short, you share your report under the 2020 regs, right? So there is an obligation. We've discussed this throughout. The 2020 regulations are really kind of all about transparency and about exchanging of information, right? And that is the same with the investigative report as well. That does need to be shared out prior to then moving on to the decision-making portion of the Title IX grievance process. And really, the point I want to drive home about this is that this is another reason why it is so vitally important that your investigators are well trained both in the process, but also in the writing of the report, because this is not something that you're only going to see internally or that only one person is going to see, right? The parties to this are also going to see this report. So I'm not going to belabor the point. We're at 11:30, but training, training, training always, and this is yet another reason why. With that, I'm going to turn it back over to Caitlin.
I will also be very quick. I am talking about record keeping. The short of this is that record keeping under Title IX does not jive with any of our other record keeping statutes. It doesn't jive with the Illinois School Student Records Act, doesn't jive with any personnel record keeping requirements. Therefore, under Title IX, we have to maintain our investigation records for 7 years. My recommendation is that we're maintaining a file that lives by itself. Here's my pretty file that I started this morning, that you're putting somewhere, whether it's digital or a real file, for 7 years. Then, to the extent information in that is a student record or a personnel record, we're making a copy and we're placing it then in that personnel file or the student file, so that once that student file is destroyed, we still have our Title IX file living on its own. I am going to turn it over to Jennifer to talk about informal resolution and close us out.
Great. Well, I think we're going to have to save that as a teaser. We are out of time. Thank you, everyone, for joining. I hope these got your Title IX juices flowing as far as ideas how to improve at your district. And we will be back in a few weeks with another Top 10 themed webinar. Thank you for coming.